educational webinar series. I am Catherine Short, Partnership Marketing Manager for First Healthcare Compliance. At First Healthcare Compliance, we help you with a comprehensive compliance management solution tailored to your business, a hospital, hospital network, healthcare practice of any size, billing company, or skilled nursing facility. As part of our complimentary educational webinar series, we bring you experts from around the country to discuss relevant topics in the healthcare industry. We are so pleased to have Jennifer Gimler Brady, Partner and General Counsel at Potter, Anderson Corroon LLP. Jennifer is the immediate past chair of the firm's litigation group and former member of the firm's executive committee, on which she served for over a decade. She currently serves as the general counsel to the firm. Ms. Brady concentrates her practice in the area of health law, labor and employment law, and commercial litigation. She regularly advises long-term care providers, physician practices, and other healthcare providers on a variety of issues, including licensing and certification, fraud and abuse laws, medical privacy and confidentiality, and litigation matters. Jennifer also counsels employers on labor and employment issues, including unionization and collective bargaining, employee supervision, discipline and discharge, sexual harassment, and employment discrimination. Jennifer is a frequent lecturer on topics such as employment practices, fraud and abuse laws, long-term litigation and regulation, medical records confidentiality, compliance under HIPAA, and medical practice management. Recent speaking engagements include seminars on exclusions under federal health care programs, reasonable accommodations under Americans with Disabilities Act, business associate agreements under HIPAA, and hot topics for employers. A copy of the slides is available for download on the control panel. Feel free to submit questions into the question box on your control panel during the presentation. We will address questions at the conclusion of the presentation. Your PACOM and PMI CEU certificates will be emailed to you following the broadcast. Your PACOM certificate will come directly from PACOM, and your PMI certificate will come from our email. There is no need to request either one. Additional CEU opportunities will be available to BC Advantage members following the live broadcast. See their website for details. A download of the handout is available with a button on the bottom right-hand side of your screen. So Jennifer, warm welcome. Thank you.
Thank you very much, Catherine. I appreciate the introduction. I appreciate the opportunity to speak with you all today regarding the role of boards in healthcare compliance. I would preface my comments by saying that the most, and by that I mean a majority of healthcare organizations are nonprofit forms, but there are certainly plenty of for-profit organizations in the healthcare space, for-profit pharmaceutical companies, different kinds of medical device and medical service providers. They can fall into the for-profit realm, but a lot of organizations like hospital systems and other types of providers may be in the nonprofit space. But the comments that we're going to cover today regarding boards' duties, boards of directors or boards of trustees, and their duties in relation to managing and oversight of healthcare companies are similar regardless of whether you're talking about a nonprofit or a for-profit organization. So bear that in mind as we go through the presentation today, and where there might be subtle differences or less than subtle differences, I will try to point them out, but I just wanted folks to understand that going through the comments. I would also say that to some extent you might hear boards of directors. That is often a very common parlance in the for-profit space for for-profit organizations versus a board of trustees, which is a common term for nonprofit organizations, but they really can be used interchangeably, and I can certainly point you to for-profit organizations or nonprofit organizations that refer to their organizational boards as boards of directors. So Just bear that in mind. But I have on the screen now a table of contents, if you will, for this presentation today. We're going to talk a little bit about the role of nonprofit boards, or boards generally, and we're going to cover the duties of trustees, the liability of trustees, the rights that trustees have in relation to the organization and their oversight responsibilities. We're then going to talk specifically about the role of boards in healthcare compliance. And then we'll end the presentation with a compliance hypothetical that hopefully will take everything that we've learned and discussed this morning and apply it to a fact pattern. So why don't we get underway? So in relation to the role of nonprofit boards, the proper role of a board is to manage and direct and oversee the affairs of a corporation or an organization. And if you'll notice that the operations of a board versus the operations of senior management are interrelated but different functions. A board, probably the most important term in that definition or that description is oversight, or oversee the affairs of the organization. Management, your senior management team, is charged with the day-to-day responsibility for running the organization. But the board is charged with overseeing the affairs of the organization and making sure that it is being run consistently with the mission or purpose of the organization. A board functions as a decision-making body, and trustees ordinarily have the power to act on behalf of the board or the organization, and that's trustees as a group, as a whole. But it's not unusual, particularly in a nonprofit realm, for trustees to sometimes take a more active role or direct role in certain aspects of the day-to-day affairs of the corporation. That may be due to the size of the organization and it being fairly limited in terms of staffing. And so board members may bring particular expertise to an organization that lends itself well to operational functions. A couple of things that come to mind might be the accounting or financial operations of an organization, marketing functions, personnel functions. Boards often have members who have particular expertise in those areas and others, property maintenance and facilities, things like that. And often, particularly in a nonprofit realm, board members will lend that expertise to the day-to-day operations of the organization. But in general, organizations want to have divisions or boundaries, if you will, between the oversight function of the organization, which is the province of the board, and the day-to-day operations of an organization, which are the province of the senior management team. And again, if you think about it logically, having the oversight responsibility for the organization lodged with the board, it's helpful to have some distance and perspective from the management responsibility of the day-to-day operations, so that as a board you can assess those operations and whether the organization is being run effectively on a day-to-day basis. So what are some of the typical responsibilities of boards? And again, I couch this in terms of nonprofit boards, but many of these concepts apply equally to for-profit boards. And probably the overarching responsibility of a board is to establish a mission and organizational values and ensure that these are approved and by the board and followed by the organization. That means management, employees, and volunteers. You set the tone for the organization. And not every board is going to establish the mission. Many organizations exist for for many years and have a long established mission. And in those organizations, the board is there to make sure that the organization aligns with that mission, or if the mission has changed over time, that the mission is adapted to the present day, and that the organization is following that revised mission as well. The board often will approve significant policies and policy changes, not necessarily the day-to-day policies like parking policies or reimbursement policies for basic business expenses, things like that. We're talking about high-level institutional policies, perhaps non-discrimination policies, codes of conduct, things like that, where, again, you're really kind of setting some basic parameters for how this organization is going to be run and the values that this organization has. So you'll see board approvals of policies at that level. Boards act as stewards of the organization's human and financial resources. That is part of the fiduciary duty. We're going to talk a little bit more about board members' duties to the organizations that they are serving. But with regard to stewards, again, that doesn't mean that boards are approving the day-to-day financial operations of the organization, but they are aware of the financial standing of the organization. They're making sure that resources are being used appropriately and consistently with the mission of the organization, and they're also making sure that the employees of the organization are being treated appropriately, that they're compensated fairly. So boards have roles in determining compensation policy, and that the structure of the organization is such that employees are treated fairly, consistently, non-discriminatorily, and that they are essentially treated well. Boards also look at the where you have investments. You may have organizations with endowments or other investment accounts. The board is charged with making sure that resources are appropriately invested and are applied to fulfilling the mission of the organization. And as I note here, they're also responsible for making sure that new resources are developed, i.e. fundraising. In the nonprofit space, one of the fundamental responsibilities of the board is to oversee the fundraising on behalf of the organization, to make sure that the organization is as well positioned as it can be financially and is sustainable, that its operations are sustainable, and that it has a stable and sustainable financial model. One of the topics, the main topic for today's discussion, is the board's responsibility for ensuring compliance. And there are lots of different ways that responsibility can come into play in an organization, and that boards can fulfill their responsibilities. One aspect of compliance for a board is to make sure that it is familiar with the organizational documents of the corporation and understands the trustees' fiduciary duties with respect to the organization. By organizational documents, I mean charter, bylaws, other mission statements, other key documents of the organization, and that the trustees understand their fiduciary responsibilities in relation to the organization. Another important part of a board's function is long-range plans. You'll often hear that boards focus on strategic, while the senior management focuses on operational. Strategic means exactly what it says. Where are we now? Where do we want to go? And how do we get there at a high level? That is a very typical board function, to be involved with long-term strategic planning on behalf of an organization. organization. A board will also approve significant changes to the structure of the organization and any kind of technological innovation or utilization that can affect the corporation's ability to fulfill its mission. So if you look back in healthcare organizations, say 20 years ago, the technological advances and basically integration into healthcare operations have been astounding. And with those technological advances, one thing that comes to mind is electronic medical records and how many organizations have really gone completely paperless. But with that comes expense. To adopt and support those technological systems that allow you to have that electronic medical record, but then also all of the data security issues that go along with it, and then the expense that goes along with both of those functions. So those are significant investments of healthcare organizations, and the board is charged with understanding how the technology plays, the role that technology plays in the organization, as well as the expense and maintenance of those types of operations. And the board will also develop strategies and approve proposals for significant relationships. If the organization is doing an affiliation, for example, or perhaps merging or acquiring another provider. Those kinds of really game-changing types of relationships and proposals, those all fall within the province of the board as well. So here are some additional responsibilities, which I would call a little more of the day-to-day nitty-gritty work of a board. They would include approving the annual operating budget, overseeing compliance and financial integrity. Many boards, for-profit and nonprofit, have audit committees and finance committees and compliance committees, all of which are devoted to ensuring that the organization is compliant with the regulatory provisions that may impact or apply to its business, to the business of the corporation or entity, as well as the financial integrity requirements, that the accounting rules are followed, that financial disclosures are appropriate and accurate, so that's a very important function of the board, and again, consistent with its compliance responsibilities. The boards will establish internal control procedures and review compliance with such procedures. One of the things you're going to hear about consistently this morning is a board's compliance function is not just specific to making sure that procedures are in place. There's a follow-up responsibility, and that is ensuring that the procedures are being followed. And if procedures need to change or adapt to the organization, to changes in the organization, that the board is ensuring that those procedures change with the organization. It has to be a dynamic compliance responsibility, not a static one. It's not a checklist approach where a board can say, okay, we have a policy for this, we have a policy for that, and then consider their job done. That oversight function that we talked about at the beginning of the presentation, it is fundamental, and it involves not just making sure you have the right things in place, but making sure that those things are working and working as intended. Boards will select outside independent auditors to kick the tires, if you will, on the financial operations of the organization and make sure that the organization is financially sound and is following sound financial policy and controls, and they do that by engaging an independent auditor to report to the board and to audit the functions of the operation and to report to the board. As we've talked about, reviewing technology plans and significant transactions and contracts. Also, boards are involved in the oversight of election and removal of officers of the corporation. Those are important functions. functions. Boards are very involved in retaining and recruiting and retaining the senior leadership of the organization. That function can't be underemphasized, shouldn't be underemphasized, because that's that you're picking the leadership of the organization and the person that is going to be moving the organization forward. So it's a very important board responsibility. And one of the oversight functions is to periodically review your corporate documents and organizational policies to ensure that they remain compliant, that they're up to speed, and that they are completely consistent with applicable laws and governance best practices. So again, it's not just doing things as we've always done them or business as usual. The compliance function, and it requires you to review periodically and update. Particular duties of trustees. We'll cover some at a high level. I'm emphasizing Delaware law for a couple of reasons. One, I'm a Delaware lawyer and barred and licensed in Delaware, but also because so many organizations are incorporated under Delaware law, and it's likely consistent with laws of other states, the corporate laws of other states, but I have focused on and highlighted some aspects of Delaware law on corporate governance issues. So trustees of a healthcare operation, or really any operation, are charged with fiduciary duties, duty of care and duty of loyalty, which includes an obligation to act in good faith. And in addition to traditional fiduciary duties, the members of a governing body of a nonprofit also have a special duty to advance the charitable goals of the corporation and protect its assets. That's essentially a longer way of saying that nonprofit directors owe a special duty to advance the mission of the organization and ensure that the organization's assets are applied to its charitable purpose. Whereas in contrast, for-profit boards are focused on maximizing shareholder value. And our court in Delaware has emphasized that fiduciary duty does not operate intermittently, but is the constant compass by which all trustee action for the corporation must be guided. And another way of saying that is the board, the trustees should put their duty to the organization ahead of any personal interest or interest that's not aligned with the organization. A little more information on the duty of care. Some general standards. The duty of care focuses on the process, how decisions are made, and it requires trustees to apply the same kind of care and prudence in managing the affairs in the business of the organization as they would apply to managing their own affairs. The point that I think is so consistent with today's discussion about compliance is this third bullet point, that trustees must inform themselves of all reasonably available information that is material to their decision. That is consistent with an obligation, as I mentioned, not to just do things business as usual, but to kick the tires, to ask questions, to be informed, including getting information from outside of the organization so that you can be informed about what's going on in the world around you, particularly in the healthcare space. What important things are impacting the business of the organization and what other options are available. Trustees have an obligation to seek additional information and not just accept information from senior leadership when they're asked to make very significant decisions that affect the operations of the organization. We'll see that in play going forward a bit in the discussion. Trustees need to take sufficient time to deliberate regarding their decisions so that they're making well-informed, well thought out, appropriate decisions. And again, making sure that they've kicked the tires, they've asked questions of their management team, of their advisors, and they've had a chance to talk among themselves. As I mentioned earlier, boards typically are comprised of folks that have particular expertise or interest in an organization. It may not be that they are healthcare, they're steeped in healthcare. They could be steeped in commercial real estate or in the business of law, or they are financial advisors, or they are property managers. Typically, boards try to be as diverse as possible so that that expertise is available among the board members, so that when issues come up, I, as a lawyer, may not be particularly well suited to asking hard questions about financial records of the organization. But if you have financial advisors, investment bankers, accountants on your board, one would expect that maybe they could really help guide the discussion and share their knowledge and expertise with other members of the board, so that the board, when the time comes to make a decision, is able to make a very well-informed, well-balanced decision on behalf of the organization. Delaware law applies a gross negligence standard in determining whether a business decision by the board was sufficiently informed to satisfy the trustee's duty of care. That's a pretty deferential standard to the board, but boards can't assume that they're always going to that the wisdom of their decisions is always going to be deferred to or accepted. It's important that the record of the decision-making process clearly establish that the boards made a well-informed, well-deliberated, appropriate decision for the organization. The duty of loyalty essentially requires trustees to put the best interests of the organization that they serve ahead of their own. It's implicated if anytime there's a material conflict of interest, or a board member is not independent from somebody who has a conflict of interest with respect to the matter under consideration. For example, if and I'll use the example of a lawyer sitting on the board. If the organization needs legal services and the lawyer board member's firm is counsel to the organization, it may be advisable for the attorney board member to stay out of or recuse himself or herself from discussions relating to the retention of the law firm because they have an obvious financial interest as an employee or partner in the law firm in relation to business from the corporate organization. So staying out of that and recusing oneself is advisable, because that's could be a conflict of interest. And boards shouldn't assume that a conflict doesn't exist just because a trustee doesn't get any direct money or tangible benefit from a transaction. There's still other ways, non-monetarily, that somebody could be advantaged by a particular transaction. So the duty of loyalty really boils down to expecting trustees to conduct themselves scrupulously and put the organization's interests ahead of their own. And within the duty of loyalty is the duty to act in good faith. And that just means that the trustee is acting and motivated to act on behalf of the organization honestly and not in a way that is knowingly unlawful. The duty of obedience flows through to nonprofit boards of directors, and that's essentially reflective of your duty to advance the corporation's mission, the nonprofit organization's mission, and protect its assets to ensure that they are devoted to furthering the mission of the organization. So what are some of the oversight obligations of a board? There are those fiduciary duties that we've covered. They give rise to oversight obligations that require trustees to make sure that policies and procedures are in place to ensure that the organization is complying with legal, regulatory, and financial requirements. Under Delaware's law, for a trustee to be liable for breach of oversight duties and oversight responsibilities, you really have to show that there is a complete failure by trustees to implement any reporting or information systems or controls, or, and this is perhaps the worst situation, where you have a system of controls, but there's a conscious failure to monitor or oversee the operations that basically prevents the trustees from being informed of things that require the trustees' attention. So as I mentioned earlier, it's not a static process, particularly with regard to compliance and in oversight. You can have systems in place, but if you're not monitoring those systems and learning from those systems in terms of what they are, the information that they're revealing to you, and whether or not they're potentially revealing a problem that requires a trustee's attention, if you're not doing that, you might as well not have any system of controls in place, because it is not effective, and nor is it compliant to have systems but not make sure that those systems are working as intended. And I have included this quote, which I think is very helpful, from a Delaware case, Stone versus Ritter, where trustees fail to act in the face of a known duty to act, thereby demonstrating a conscious disregard for their responsibilities. They breach the duty of loyalty by failing to discharge their fiduciary obligation in good faith. That sums it up, I think, fairly concisely. So again, with some practical guidance for the oversight responsibilities of trustees. Trustees are expected to establish appropriate oversight and controls at the board level to be sure that the organization is complying with all applicable legal and regulatory requirements, and to be vigilant in monitoring the organization's operations and ensuring the effectiveness of its audit and compliance functions. You can't just have committees that are charged with these responsibilities, but they're not doing what they should be doing. It is, as you know, when we talk about some compliance situations, or more appropriately, situations where organizations have not done what they should have done in relation to compliance, and they've gotten themselves sideways with, say, a federal regulator, one of the remedies for a violation, say, for example, fraudulent billing, or major security breaches. One of the potential remedies that regulators have at their disposal is a corporate integrity agreement, which they would require the organization to enter into as part of a resolution of the the incident, if you will, or the situation. Those types of agreements, often referred to as CIAs, typically include board level action requirements. They may impose training responsibilities on the board. They may impose certain specific actions on behalf of the board, that the board takes certain actions, perhaps require the adoption of particular committees or policies. Those are situations where essentially an organization's board has failed in its compliance function, or at least a government regulator feels that it has failed in its compliance responsibility, so they're going to impose them on the board through a CIA. And again, that's reflective of the government's view as well of the importance of the oversight responsibility of boards of directors. And you can't overstate the importance of that oversight responsibility with regard to highly regulated businesses like healthcare. Healthcare operations have many moving parts to them. They are highly regulated, and they offer the opportunity for many missteps. Billing and documentation requirements for Medicare and other payers, huge area of exposure for healthcare operations because of the potential applicability of the overpayment rules and the False Claims Act and the anti-kickback statutes and the Stark anti-referral, self-referral laws. They are particularly vulnerable areas in terms of billing and payment for healthcare operations. Procedures for handling controlled substances. Increasingly in this era of the opioid epidemic, how organizations are handling controlled substances and accounting for them, another area of vulnerability for healthcare organizations. Professional licensing for staff as well as entity level licensing. Lots of issues can happen if you're not ensuring that your staff are appropriately licensed and that the entity is appropriately licensed. If licenses lapse, if they don't get renewed, and you have providers providing services and then billing for those services to certain healthcare payers, particularly federal government payers, Medicare, Medicaid, TRICARE, you could be looking at significant penalties because services should be provided by licensed staff. And the government could take the position that because the license lapsed, that those services provided by that staff member were not appropriate and should not have been billed for. And sometimes license lapses can go over significant periods of time. And if you have, say, a nurse or a physician that inadvertently didn't renew his or her license and was providing services to multiple residents over or patients over multiple days, you could easily see how any billing for those services, directly or indirectly, part of perhaps a set price for a service, but there's still a service provider in that packaged service, if you will, that could completely invalidate that billing. So it's a huge potential exposure for organizations to ensure that licensing is up to speed and up to date. And of course, the one that comes to the forefront frequently is compliance with the HIPAA privacy and security regulations and other applicable data security requirements. This is perhaps one of the most active areas of exposure and liability, as well as enforcement activity for healthcare organizations. So this is a huge issue and oversight responsibility for boards. And boards should also be aware of claims that the organization may be vulnerable to based on what's happening in other enforcement actions or in private litigation against similar organizations. So it's not unusual for enforcement trends to target, say, particular industries. So if you are in the nursing home business, for example, there may be a particular focus on a particular type of issue in nursing homes, maybe too many falls, maybe dehydration, maybe medication errors. And you will see trends emerge on enforcement activity and private litigation. As a board member, you need to be aware of those kinds of things so you can help your organization determine whether it has a similar problem potentially, or hopefully just make sure that it is as well positioned as possible to defend itself should it be the subject of that type of claim. Other types of things that may run along an industry would be either false claims type enforcement. There are multiple cases right now relating to opioid prescribing and misrepresentations by the alleged misrepresentations, I should say, by the pharmaceutical industry about the potential addictive nature of particular medications. Those are trends that if you're in those businesses, your boards need to be aware that they're happening and kick the tires on your own organization to see whether you may be vulnerable or whether your practices are such that you are well positioned to defend yourself if those types of claims would come your way. What are some of the rights of trustees as well? So we've talked a lot about your oversight responsibilities and the obligations that are on individuals as trustees. And now we'll talk a little bit about what your rights are to help you. These are things that help you do your job as a trustee. And first and foremost, trustees are entitled to receive information that will help them fulfill their duties, including evaluating matters that they're being asked to approve and fulfilling their duty of oversight. So employees are not only entitled to request information from the organization, from the management functions of the organization, but they are obligated to do that. So again, that they can ensure that they're not just listening to reports periodically from senior management, but they're also testing those reports and making sure that they have all of the correct information at their disposal. Board members have a right to copies of all minutes of the full board meetings as well as committees of the board. I would say that that's also a very important function and responsibility of board members to review those committee reports. A lot of actions, a lot of the work of a board occurs at the committee level, so that if you are not a member of a particular committee, you're going to want to at least familiarize yourself with what those committees are doing, so you're aware of that work of the board as well, because you're charged with knowledge of what those committees are doing as well. Trustees have a right to inspect the books and records of the organization for a proper purpose, and a proper purpose is really anything that's reasonably related to a trustee's position as a trustees. Trustees are entitled to notice of meetings of the board. How those meetings are set are typically addressed in the bylaws of the organization or other meeting schedules that are other meeting guidance that sets how frequently and when and where a board should meet, and they typically provide notice and explanation of how a special meeting is called and when under what circumstances a special meeting may be required. And if notice isn't properly provided, trustees have the right to object to the holding of such meeting because it could impact their ability to participate or participate fully. And trustees have the right to vote against matters put to a vote of the board and have their dissent noted in the minutes of the meeting. It's important as we talk about the compliance responsibility or the compliance function of the board to talk a little bit about the liability exposure of trustees. And trustees may be liable to different constituencies. They could be liable to the corporation itself, the members of the corporation, and the constituencies served by the corporation if they don't fulfill their duties and obligations to the corporation. And even if trustees aren't liable, the corporation could still be liable for violations of law, such as breach of contract or tort, or failure to comply with tax obligations or employment laws. It could be liable for negligent acts or omissions by volunteers or employees under the doctrine of respondeat superior. And trustees are obligated to make sure that they're aware of the potential liabilities of the organization and take steps to implement oversight procedures that are designed to limit such claims. So the bottom line is, while an employee or a trustee may not be individually liable, the corporation could still be liable for non-compliance that results in harm in some way. And it ultimately could be due to the fact that the board wasn't as attentive to its compliance responsibilities as it should have been. Just a note about Delaware law does provide the opportunity for organizations to limit personal liability of trustees for monetary damages for breaches of fiduciary duty. However, liability cannot be limited in any instance of a breach of the duty of loyalty, i.e. in situations where the trustee may have put the trustee's interest ahead of the organization, or acts or omissions that are not in good faith, or an intentional misconduct or a knowing violation of the law, and any transaction in which a trustee derives an improper personal benefit. Those are instances where trustees cannot be insulated from liability, from personal liability. So let's talk about the compliance function. We've touched on a few areas of compliance at a higher level, but here we want to drill down a little bit and talk about the compliance function of the board in a little bit more detail. So what is compliance? It essentially promotes the prevention, detection, and resolution of actions that don't conform to legal, policy, or business standards. It is the function of ensuring that the organization runs the business consistently with the law or regulations or other business requirements that are applicable to that organization. The board role or function in the compliance area can be advanced by a few things. One, the board either forms or enforces or follows a clear mission statement for the organization. We know what this organization is about. We know what it's not about. We know what the organization is charged with doing or delivering, and when it strays from that mission, the board should rein it back in. The board's function is a compliance function also involves carefully selecting and supervising your outside advisors. Boards can't know everything. I mentioned that boards try to be as diverse as possible in their how they're structured and the expertise of the individual trustees, but often organizations can't possibly cover or have represented on the board all of the areas of advice that the board may need to ensure that it's following and implementing its compliance responsibilities to the most effective extent. So there's a need to engage outside advisors, and the board doesn't want to do that lightly. It wants to make sure that it carefully vets the outside advisors that it engages, and it ensures that they really are the appropriate advisors for the task at hand. boards should also be careful about observing corporate formalities, which are just as important for nonprofits as they are for for-profit organizations. When I think there's a general theme that if you're not minding the basics of the store, you may be really not minding bigger issue problems, kind of bet the company issues. So you want to see organizations that elect trustees properly and in a timely manner, that they keep the formalities of acting at meetings of the board and at formal meetings of the board and not kind of on an ad hoc basis, that they keep minutes and records appropriately, that they delegate functions to committees that are appropriately comprised and don't have folks who are non-trustees. And I say that with a caveat. Many board committees of organizations have members that, for lack of a better term, are co-opt. They may not be full board members, but they have particular expertise. So it's not completely inappropriate to have a board function delegated to a committee that would include people who are not trustees, but it can't be a full delegation to a committee that's comprised solely of non-trustees. That would not be a good corporate form to follow. And failure to comply with statutes and organizational documents, also not a good sign. These are very basic functions of a board, and one would typically want to see that a board is following those responsibilities, those basic responsibilities. Another important aspect of compliance for a board is to make sure that there are formal lines of reporting potential compliance problems, not just to superior officers or your senior management team, but directly to the board. And to have an effective compliance program, an organization should have a compliance officer, a culture of compliance, and oversight of the compliance program by the governing board. One of the ways the board can execute that oversight is to have a reporting function or a line of reporting available to the board, so that if, for example, there was a concern that senior management was engaging in improper billing to maximize the revenues of the organization, you want to have some mechanism in place for that information to be reported directly to the board, perhaps through a compliance officer or directly, so that the somebody who was concerned, a potential whistleblower, could make the board informed of that situation in time to give the board an opportunity to investigate and act. It's really important, as we've emphasized already, that boards inform themselves and stay up to date on really ever-changing requirements that may impact an organization. And this is particularly important in healthcare organizations, because the state of play for healthcare organizations can change so quickly and so rapidly that it's essential that boards stay up to date. And how can they do that? If you are a member of a board and you're not a healthcare you don't work in the healthcare space in your day-to-day position, how can you learn everything that you really need to know to be an effective board member? You can do periodic updates from staff during regular meetings. You can have presentations by outside advisors. What's new, what's important, what should I be aware of as a trustee of a healthcare organization? You want to make sure that you do recruit knowledgeable board members so that you have some expertise available to you. Attending outside training programs is a great way for trustees to really inform themselves of the realities of the what's going on in their particular industry or in healthcare generally. And the overarching goal is to make sure you understand the business climate and have enough knowledge to know what questions to ask so that you can ensure that you're making the best decisions possible, the best informed decisions, and you're identifying areas of particular risk. If the organization is dealing with federal healthcare programs, I strongly recommend the organization be in the board read the practical guidance for healthcare governing boards on compliance oversight from the Inspector General, the Federal Inspector General. It's a wealth of information about the compliance function of healthcare boards. One big theme, and as I mentioned earlier, about you also see it in corporate integrity agreements when companies have gotten sideways with federal regulators. There's a big emphasis on training. There's a big emphasis on the practical guidance and in CIAs about training of the board members to address the responsibilities regarding corporate governance and review and oversight of the organization's compliance plan. That training should include the unique responsibilities of healthcare board members, including risks, oversight areas, and strategic approaches to conducting oversight of the healthcare entity, and also emphasize the role of the board in setting the tone for the organization as one that promotes integrity and ethical conduct. Board members should understand that they are expected to walk the walk or model the behavior and serve as examples of compliant and ethical behavior. So we're going to wrap up with a hypothetical that covers some of the points that we've talked about in a real world situation. Names have been changed to protect the innocent. So here we have a compliance hypothetical with ABC Healthcare. It's a large metropolitan healthcare system. It's aware of HIPAA. It has a policy and program for HIPAA compliance. It has notices of privacy practices and security procedures. And back in 2016, it engaged an IT consultant to audit its processes, its technology processes for handling protected health information. Very common. It's part of an organization's ongoing efforts to look for risks, look for vulnerabilities. So they hire an IT consultant. IT consultant does the audit and identifies multiple recommendations, including that ABC encrypt its laptops. These laptops are used by healthcare providers to document in the healthcare system's electronic medical record. And at that point, the auditor found, or the consultant found, that many of the laptops were not encrypted. And their report, the IT consultant's report and recommendations, went to the senior management team of the organization as well as the audit committee of the board. In the fall of 2018, so fast forward 2 years, an ABC physician had his laptop stolen from his car. The laptop was not encrypted, and it provided a gateway to the protected health information of more than 25,000 patients, including such identifying information as names, addresses, birth dates, social security numbers, medical record account numbers, etc. So, does ABC's board bear any responsibility or potential liability for the breach? And I think the answer to that question is going to be, it depends, and it depends on more facts. If you have a record that shows that the board took that report from the IT consultant, studied it, convened senior management and the IT function, and wanted to understand what the issues were, the action plan for addressing those issues, and essentially did a decent job of informing itself and trying to ensure that the organization addressed those risk, those gaps, if you will, then the board is probably pretty well positioned to say that it functioned well and that it executed on its compliance and oversight responsibilities. If that didn't happen, if the board just kind of went, oh, here's some vulnerabilities and we'll talk about it at some point, you could see a situation where the board may have some responsibility for not following through, for not ensuring that the organization addressed those risks that had been identified for the very issue of that actually occurred. Those risks were identified for the potential exposure or improper access to protected healthcare information, and that is exactly what ultimately happened in this case. So what are the potential exposures? There have been a number of data breach cases that you all have heard of. You had Target, Experian, Yahoo, where millions of individuals' records were improperly accessed. And so, and not surprisingly, there's been a fair amount of litigation that spins off from those actions or those incidents, including breaches of fiduciary duty claims, invasion of privacy, negligence, breach of implied contract, and violation of various state and federal statutes on data protection, HIPAA and state counterparts to some extent, or just data security statutes generally that aren't specific or limited to healthcare operations. In the for-profit context, you could face a shareholder derivative action that as a trustee or director or an officer. In the 1996 Caremark decision, the Delaware Chancery Court declared that in such actions, directors can be personally liable for failure to appropriately monitor and supervise the organization or the enterprise. Directors and officers should be very wary of demonstrating a conscious disregard for their duties or ignoring red flags, because doing so can result in a director being held personally liable for a corporation's losses. And depending on the additional facts or the lack of additional facts in this hypothetical, you could easily see a case being made that directors did not follow up on red flags that were identified by the IT consultant. So steps that a board could take to protect the organization in this kind of a context with data security: hire the right people, make sure you have a security officer, and engage the appropriate technical experts to do risk assessments and educate officers and board members on data security risks and the best way to mitigate those risks. You may want to have a board committee that's focused exclusively on data security, and you'll see this more and more because data security issues are increasingly an area of exposure for organizations, significant exposure. You want to regularly address and deliberate when deciding issues of data security and carefully document those deliberations to demonstrate appropriate care. That falls back to my additional facts information. If in fact the board took that report, studied the IT consultant's report, and put into place steps designed to encourage senior management to address those risks, then they probably are going to be in a good position to demonstrate that they exercised appropriate care. Training, you cannot underestimate the value of training and ensuring that it's ongoing and regular, because data security issues are evolving all the time. So conducting a training session on data security 2 years ago probably isn't enough to show that the organization is trying to stay up to speed and stay ahead of that issue. We've mentioned about ensuring their pathways for reporting concerns directly to the board, adopting a security plan that is tailored to the specific risks that your organization faces, and underscoring the last point, following up to ensure that identified risks have been addressed. You can't just say, I'm washing my hands of it and I've put it on somebody's desk. You need to make sure that there's follow through and that the problems have been addressed. So I would be happy to entertain any questions about the compliance function of a board.
Thank you so much, Jennifer. That's very, very informative. I really appreciate that. We do have a few questions. So let me give you the first one here. So what are some of the biggest risk areas for healthcare organizations, and what role does the board play with regard to those risks?
Well, a great question, and I think we talked about a couple of them, and I would say today the biggest risks for healthcare organizations would be in the area of data security and in the area of billing compliance, because there are so many ways on the billing side that organizations can get into trouble, some intentional, but often completely unintentional. Anybody who's involved with healthcare billing knows how completely complex and challenging it can be to make sure you pick the right codes and the right number of units. So the possibility of errors is pretty significant, and that's in an innocent context. If you have intentional overbilling or upcoding, those kinds of issues, that potential exposure, particularly with the penalties that could be applied to the organization, you really have to be, as a board, you have to ensure that the billing functions, the accounting functions of your organization are completely compliant. And data security, I think, is we're just scratching the tip of the iceberg on data security issues, and because of the nature of information that healthcare providers maintain, the amount of personal information, it's not just what your diagnosis is and what medications you're taking, but it's your name, address, maybe your likeness, maybe your financial accounts if you pay with credit cards, your social security numbers. It's such a treasure trove of information that healthcare providers maintain that they are very rich targets for people who are bent on trying to access information improperly and steal it for nefarious purposes. So I would say those are probably the two biggest areas of concern for healthcare boards in terms of compliance monitoring.
Okay, thank you. So another question here. Is it necessary for board members of healthcare organizations to have backgrounds and experience in healthcare operations?
Another great question, and because I think you could take from my remarks today that having that background may be essential, and I don't think it is. And in fact, it may be helpful to not have that background, because you could be the person that asks a lot of questions and frankly gets the people who are in healthcare on a day-to-day basis to think about things in a different way, or to think about things they hadn't thought about before because they're immersed in it on a day-to-day basis, and it doesn't raise any questions for them. So I would say that while it could be helpful to have a background in healthcare, because there's just so much terminology and so many regulations that apply in healthcare, that having some working knowledge of them may be an advantage. I would also say that having no involvement in that area could be very useful, because you're learning and you're asking questions as you go, with the caveat that if you don't have the knowledge and background, the board needs to make sure that through its training or orientation or other educational opportunities made available to that board member that doesn't have that background, they can get up to speed and they can learn. So I think as long as the training and the education is offered, I don't think it's absolutely essential that a member of a board actually be well versed in healthcare or work in the healthcare independently.
Okay, great. Oh, okay, another great question here. Is it the board's responsibility to develop a healthcare organization's compliance plan, or is it legal's, or is it the compliance department, or whose responsibility is it to develop the healthcare organization's plan and
All of
compliance?
the, I think that the quick answer would be all of the above. A compliance plan is a comprehensive plan that should touch upon all major operations of the organization. And to do that, you really need input from all of those operations. From legal, you need to understand what the laws are that the organization has to comply with. From the compliance department, you need to understand what the resources are that are available and what the expectations are for the organization if non-compliant conduct is observed. From the board, remember at the outset we talked about that policy setting role of the board, and a compliance plan is certainly the type of high-level policy and program that you're going to want to have the board's stamp of approval on. So I would characterize it really as a collaborative exercise that no one group should have sole responsibility for, because, and I didn't even mention the senior management team and the leadership team and the role that they play. It's really a collaborative process to come up with the compliance plan, an effective compliance plan for the organization. But that said, it's essential that the board understand the compliance plan and apply it regularly, and understand its role in relation to that compliance plan, whether it's the recipient of a report of non-compliant conduct and, depending on the nature of it, either referring that to the appropriate department in the organization for investigation, or depending on the nature of the allegation, it may be something that has to be handled at the board level. For example, if you had a report that the CEO of an organization was engaging in inappropriate conduct, and that compliance report, a compliance report is made to the board, it may be that the investigation and follow-up of that particular issue has to happen at the board level because the board is the supervisor of the CEO. In other cases, it may be appropriate to refer that to the Department of, the Human Resources function or the accounting function, or, another maybe the IT function in the organization. It really just depends on the nature of the allegation. But the bottom line is the organization as a whole needs to be well versed in its compliance program, and it needs to be a collaborative effort to put together a really effective plan.
Got it. Got it. Okay, here's an interesting question here. What are some key things a board should look for to assess whether an organization's compliance plan and culture are effective?
Well, but that's a broad question, but I think a couple of things that a board can look for. And one is in relation to reporting lines. Are you getting reports? Some organizations, as part of their compliance program, will have procedures to report concerns directly to the compliance department or the chief compliance officer. Some organizations simply aren't that big to sustain a dedicated compliance officer. So they may have other types of compliance reporting structures. Some organizations may have 800 numbers where employees can report things anonymously, and in any number of combinations. A board should be looking at whether or not compliance reports are being made. It may be, if they're not, that you have a completely compliant organization, which is a wonderful thing. Or it could be that people don't understand their reporting structure and don't understand the ways that they could bring concerns forward. So a board should, I've used the term kick the tires. That is certainly something a board should do, is look at whether or not the reporting structures are known to the employees, known to your staff, known to your constituents, your patients, and are they being used? And if they're not being used, and they're not, the compliance function is not getting reports, I don't think the board should necessarily rest on the assumption that, oh, we have a great, wholly compliant organization. The board should examine whether or not the reporting structures or the reporting lines are appropriate for the organization or may need some tweaking. A board should also make sure that it is educated enough in whatever realm to ask questions. Just taking reports verbatim and not questioning findings, whether they be in the financial realm or in the technology realm, that is not going to satisfy the board's obligation to look behind the information that's being provided and ask questions, because the board can't just simply accept a report and say, okay, we're done here. We've completed our compliance responsibilities. You need to make sure that it makes sense. The information that you're receiving makes sense in the context that you're operating in. So those are a couple of things that come to mind.
Great. Well, do you have any other final thoughts for us, or any other advice that maybe you've thought of during the presentation?
Well, I just think that you can't underscore enough the board's role in setting the tone for the organization. And the board being visible, being a clear and consistent voice on the importance of compliance to the organization will flow through the organization. If really effective organizations that have robust compliance plans, you uniformly see activity and consistency at the board level in that compliance function.
Great. Well, thank you, Jennifer, so much for presenting this to us today. Really appreciate it. Thank you.
My pleasure.
Well, thank you. And thank you so much, attendees, for joining us. Please use the contact information. Do you have a contact page there, actually, Jennifer?
There we are.
Okay, great. So attendees, you can use the contact information there. Don't forget, attendees, that you can download this presentation on the bottom right-hand side of your screen, so you can have a copy of this. So please use the contact information on the screen for any questions. If you remember something later, you can send us questions and we'll forward them on also. Please remember your PAYCOM and PMI CEU certificate will be emailed to you from within 2 days following the broadcast. There's no need to request it. You'll get it automatically. You can register for future webinars or request a demo of our compliance solution on our website at firsthcc.com, or call us at 888-543-4778. And thank you for joining us.